Do you have a blended family? If so, have you ever found yourself lying awake at night worrying about how to leave an inheritance for your spouse while also ensuring your own children aren't left out in the cold? What if I told you there was a way to provide for both without any conflicts or hurt feelings? If you've ever found yourself in this situation, you're not alone. In fact, this is a dilemma that keeps countless individuals in blended families up at night. But what if I told you there was a way to protect everyone you love without having to choose between your spouse and your children? Today, I'm going to reveal a powerful estate planning strategy that could be the answer you've been searching for. It's a solution that has brought peace of mind to many of my clients, and it might just be the game changer your family needs. Now, I know that estate planning isn't exactly the most exciting topic for most people. It can seem complicated or dry, and let's face it, a bit morbid. But trust me, when I say that taking the time to plan now can save your family from a world of heartache and financial stress later. So let's dive in and explore how we can navigate the sometimes choppy waters of blended family estate planning. Before we get into the nitty-gritty of our solution, let me paint a picture for you. This is a scenario I encounter frequently in my practice, and it might sound familiar to some of you. Picture this. John and Sarah are a happily married couple in their mid-60s. They've been together for about a decade now, having found love later in life after their first marriages ended. John has 2 children from his previous marriage, Mike and Emily, both in their 30s. Sarah also has 2 children from her first marriage, Tom and Lisa, who are around the same age. John and Sarah have built a comfortable life together. They own a lovely home, have healthy retirement accounts, and have even managed to set aside some savings. All in all, their combined estate is worth about $5 million. Not too shabby, right? But here's where things get tricky. John and Sarah love each other dearly, and they both want to make sure that if anything happens to one of them, the other will be taken care of. But at the same time, they each want to make sure their own children receive an inheritance. It's a delicate balance, and one that causes them no small amount of worry. One evening, as they're sitting on their porch watching the sunset, John turns to Sarah and says, "Honey, I've been thinking, what happens to our assets if one of us passes away? I want to make sure you're taken care of, but also want to make sure that we've got Mike and Emily taken care of." Sarah nods, understanding completely. "I've been wondering the same thing myself," she admits. "I want to make sure you're okay if anything happens to me, but I also want to make sure that Tom and Lisa have an inheritance." This conversation is one I hear echoed in my office time and time again. Blended families like John and Sarah's are becoming increasingly common, and with them comes a unique set of estate planning challenges. How do you provide for your spouse while also ensuring your children from a previous marriage receive an inheritance? It's a question that keeps many people up at night. But before we get into the solution, let's look at what could go wrong if John and Sarah don't plan carefully. Now, let's fast forward a bit in our story. Let's say that John and Sarah, like many couples, decided to go with what seemed like the simplest solution. They each made a will, leaving everything to the other in case of death. It seemed logical at the time. After all, they trust each other implicitly, and they both want to make sure the other is taken care of. So let's say John passes away first. Now, according to his will, his entire estate, his share of their home, his retirement account, his savings, everything goes to Sarah. Now, on the surface, this might not seem like a problem. Sarah loved John and was devastated by his loss. She had no intention of disinheriting Mike and Emily, John's children. She even told them, "Don't worry, I'll make sure you're taken care of in my will." But there's where things can go awry. Life has a way of throwing curveballs at all of us. Maybe Sarah's health takes a turn for the worse, and she needs expensive long-term care that eats into the estate. Or perhaps she remarries and her new spouse influences her estate planning decisions. Or in a scenario that's all too common, maybe Sarah simply never gets around to updating her will. Whatever the reason, years pass, and when Sarah eventually passes away, her will leaves everything to her own children, Tom and Lisa. Mike and Emily, John's children, are left with nothing from their father's estate. Now, I want to be clear. This isn't because Sarah was a bad person or because she intentionally wanted to disinherit Mike and Emily. It's simply a result of poor planning. Without the right legal structure in place, even the best intentions can fall by the wayside. This scenario plays out more often than you might think, and it can lead to bitter family disputes, broken relationships, and expensive legal battles. I've seen families torn apart by these kinds of situations, and believe me, it's heartbreaking. But here's the good news. It doesn't have to be this way. There's a solution that can help prevent this kind of scenario, and that's what we're going to talk about next. In estate planning circles, there's a common solution to this problem, and it's one that I've seen work wonders for blended families like John and Sarah's. It's called a trust. Now, I know what you might be thinking. A trust? Isn't that something only super wealthy people need? But that's a common misconception. Trusts can be incredibly useful tools for many different types of families and financial situations. So, what exactly is a trust? In simple terms, a trust is a legal arrangement where you transfer your assets to a separate entity, the trust, which then holds and manages those assets according to your instructions. It's like creating a set of rules for how you want your assets handled after you're gone. In the case of blended families, instead of leaving assets directly to the spouse, they're left to a trust. This trust can be set up to provide for the surviving spouse during their lifetime, while also ensuring that the assets ultimately pass to the deceased spouse's children. Let's go back to our example with John and Sarah. Instead of leaving the entire estate directly to Sarah, John could set up a trust. He would transfer his assets into this trust and specify how he wants those assets to be used and distributed. For instance, the trust could be set up so that Sarah can use the income from the trust assets for the rest of her life. This way, she's taken care of financially, just as John wanted. But the trust would also specify that after Sarah's death, the remaining assets in the trust would go to John's children, Mike and Emily. This arrangement accomplishes several important things. First, it provides for Sarah's financial needs during her lifetime. Second, it ensures that John's children ultimately receive an inheritance from their father. Third, it protects the assets from being used in ways John didn't intend, such as being left to a new spouse if Sarah remarries. Now, you might be wondering, this sounds great, but isn't it complicated to set up? And you're right. It does require more planning than simply writing a will. But that's where working with an experienced estate planning attorney comes in. They can help you navigate the process and set up a trust that fits your specific situation and your goals. But before we dive into the specifics of how to set up such a trust, let's talk about some key decisions you'll need to make when establishing this kind of arrangement. When setting up a trust for a blended family situation, there are two crucial decisions you'll need to make. One, choosing the trustee, and two, determining the distribution terms. Let's break these down one at a time. Choosing the trustee. The choice of trustee is perhaps one of the most important decisions you'll make when setting up your trust. In fact, it's so important, I've even written a book called Selecting Your Trustee. The trustee is the person or entity responsible for managing the trust assets and making distributions according to the terms that you've set up. Let's go back to our example with John and Sarah. Imagine John leaves his $5 million estate to a trust for Sarah's benefit. Who should he name as the trustee? First, let's talk about the trustee's role. Typically, the trustee is given wide discretion on how to distribute assets. Occasionally, they will be guided by what's known in legal circles as the HEMS standard. HEMS stands for Health, Education, Maintenance, and Support. This means the trustee can distribute funds from the trust for the beneficiaries for health care, education, maintenance of lifestyle, and support. Another option is called a unitrust. It requires a certain percentage of the assets, say 4%, to be distributed each year to the spouse. So if Sarah needed money for medical expenses or to pay for her usual living expenses, the trustee would have the authority to distribute funds from the trust for these purposes. Now let's look at some options for who could serve as trustee. Option one, You could name the surviving spouse, in this case Sarah, as the trustee. Now, this option has some advantages because Sarah would have direct control over the trust assets and could make these distributions to herself as needed. This could provide her with a sense of financial security and control. However, there are potential issues with this approach. Remember, one of the main purposes of setting up the trust was to ensure that John's children ultimately receive an inheritance. If Sarah is the sole trustee, she might be tempted to be overly generous with distributions to herself, potentially depleting the trust assets over time. There's also the risk that she could interpret the distribution standards too loosely, using trust assets for purposes John didn't intend. Option 2, naming one's own child, for example, John's daughter Emily, as trustee. This approach ensures that someone who has John's children's interest at heart is in control of the trust. Emily would likely be motivated to preserve the trust assets for herself and her brother. However, this option comes with its own set of challenges. It could create tension between Sarah and her stepchildren. Sarah might feel like she has to ask her stepdaughter for money, which could be uncomfortable and potentially lead to family conflict. Additionally, Emily might not have the financial expertise necessary to manage a large trust. Well, there are other possibilities as well. For instance, you could name co-trustees, perhaps Sarah and Emily together. This could provide a balance, ensuring both Sarah's needs and the preservation of assets for John's children are considered. However, it could also lead to disagreement and deadlocks if the co-trustees can't agree. Another option is to name a corporate trustee, such as a bank or a trust company. Now, these entities have professional experience managing trust assets and can provide an unbiased third-party perspective. However, they do charge fees for their services, which would come out of the trust assets. You could also consider naming an independent individual trustee, perhaps a trusted family friend or a professional advisor like a CPA or an attorney who knows the family. The key is to choose a trustee or trustees who will faithfully carry out your wishes, balance the needs of all beneficiaries, and manage the trust assets responsibly. Once you've decided on a trustee, the next crucial step is determining how you want the trust assets to be distributed. This is where you can really customize the trust to fit your specific wishes and family situation. Let's continue with John and Sarah's example to illustrate some common approaches. It's quite common for the surviving spouse to receive all the income generated by the trust. In John and Sarah's case, this would mean that Sarah would receive any interest, dividends, or other income produced by the $5 million in trust assets. This provides a steady stream of financial support for Sarah throughout her lifetime. For instance, if the trust assets are invested in a way that generates a 4% annual return, Sarah would receive about $200,000 per year in income. This could go a long way towards maintaining her lifestyle and covering her expenses. However, it's important to note that this arrangement alone doesn't guarantee that there will be anything left for John's children after Sarah's death. The value of the trust assets could fluctuate with market conditions, and if Sarah lives for many more years, inflation could erode the purchasing power of the remaining assets. This is why many trusts also include provisions for access to the trust principal, which we'll discuss in a moment. For larger estates, there's an additional consideration known as Q-tip treatment. Q-tip stands for Qualified Terminable Interest Property, and it's a way to defer estate taxes until after the death of the surviving spouse. Here's how it works. When the first spouse dies, their assets go into the trust. If the trust qualifies for Q-tip treatment, no estate tax is due at that time. Instead, the assets in the trust will be included in the surviving spouse's estate for tax purposes when they eventually pass away. This can be a very powerful tool for deferring and potentially reducing estate taxes, especially for couples with substantial wealth. However, it's a complex area of tax law, and you'll definitely want to consult with an estate planning attorney or tax professional to determine if this is appropriate for your situation. While providing income to the surviving spouse is important, many trusts also allow for distributions of principal, the core assets of the trust, under certain circumstances. This is where the HEM standard we discussed earlier might come into play. In John and Sarah's case, the trust could be set up so that Sarah can receive distributions from the principal for her health, education, maintenance, and support. This provides a safety net in case the income from the trust isn't sufficient to meet Sarah's needs. For example, if Sarah had a major medical expense that wasn't covered by insurance, the trustee could distribute funds from the trust principal to cover this cost. Or if inflation significantly increased Sarah's cost of living, additional distributions could be made to help maintain her standard of living. It's crucial to emphasize the trustee's discretion in making principal distributions. The trust document should provide clear guidelines, but ultimately it's up to the trustee to interpret these guidelines and decide whether a requested distribution meets the criteria. This is why the choice of trustee is so important. You want someone who will faithfully carry out your wishes, balancing the current needs of the surviving spouse with the goal of preserving assets for your children. For instance, if Sarah requested a distribution to buy a luxury car, the trustee would need to determine whether this falls under maintenance and support. Different trustees might interpret this differently, which is why it's important to choose someone whose judgment you trust. There are many other factors you might want to consider when setting up your trust. For example, age restrictions. You might specify that your children don't receive their inheritance until they reach a certain age, or that they receive it perhaps in stages. Perhaps you want to consider incentive provisions. Some people include provisions that incentivize certain behaviors, like matching their children's earned income or providing additional distributions for educational achievements. And then we have special needs considerations. If any of your beneficiaries have special needs, you might want to set up a special needs trust to provide for them without jeopardizing their eligibility for government benefits. And what about charitable giving? You could include provisions in the trust for donations to your favorite charities, either during the surviving spouse's lifetime or after they pass away. Family heirlooms or businesses. You might have specific instructions for how certain assets, like these family heirlooms or a family business, should be handled. The beauty of a trust is its flexibility. You can customize it to fit your unique family situation and financial goals. However, this flexibility also means there are a lot of decisions to make. This is why it's so important to work with an experienced estate planning attorney who can guide you through these choices and help you create a trust that truly reflects your wishes. Remember, the goal here is to provide for your spouse while also protecting your children's inheritance. With careful planning and the right legal structures in place, you can achieve both these objectives and provide peace of mind for your entire blended family. As we wrap up our discussion on estate planning for blended families, let's recap the key points we've covered. First and foremost, if you want to provide for your spouse, but also protect your children's inheritance, don't leave assets outright to your spouse. While this might seem like the simplest solution, it can lead to unintended consequences down the road. Instead, consider setting up a trust. A trust allows you to provide for your spouse during their lifetime while ensuring that your assets ultimately pass to your children. It gives you control over how your assets are used even after you're gone and can help prevent family conflicts and misunderstandings. When setting up a trust, remember that the trustee choice is critical. Whether you choose your spouse, one of your children, a professional trustee, or some combination of these, make sure it's someone who understands your wishes and someone who will faithfully carry them out. Consider the pros and cons of each option carefully. It's also vital to set clear distribution terms for the trust. Decide how income will be distributed, whether and how the surviving spouse can access the principal, and how the assets will ultimately be distributed to your children. Be as specific as possible to avoid confusion or disagreements later. Consider including provisions for estate tax planning, especially if you have a large estate. Techniques like the Q-tip treatment can help defer and potentially reduce estate taxes. Don't forget about additional considerations like age restrictions on inheritances, incentive provisions, or special instructions for family heirlooms or businesses. These details can help ensure that your assets are used in accordance with your desires. If you have a blended family and want to take advantage of some of these strategies that I've laid out today, please go to dateandestateplanninglaw.com/get started for a free 1-hour complimentary conversation with one of our experienced estate planning attorneys. Thanks for being with us today.